Judicial activism. There is no statutory definition, nor is there any consensual connotation given to the notion of judicial activism. Judicial activism is usually described as a proactive role played by the judiciary. Justice J.S. Verma says that the judicial activism means the active process of implementation of the rule of law, essential for the preservation of functional democracy. Being an extractive term, it is described differently by different persons, while some extol it as judicial creativity and dynamism of judges, which brings a revolution in the field of human rights and social welfare through enforcement of public duties. Others criticize it by describing it as judicial extremism, judicial terrorism, transgression into the domains of the other organs of the state, negating the constitutional spirit. The two extreme views appear to have originated due to the role judiciary has played in different cases. Any amount of additional active role may lead to either judicial creativity or judicial extremism. Governance is not merely a lawmaking process, it is also law execution. Together with the establishment of justice, the three organs of the state perform three different functions. It is always impossible to put these three different departments separately and then expect a normal functioning. That is why the legislature, while doing its major job for making legislation, performs certain administrative and judicial functions. So do other organs. Fusion and not separation of functions is the key to good governance. And in such a situation, the judiciary does perform relatively a more active role. Judicial activism may not be given any more importance than what it deserves. What is important is that judiciary in its role should not abuse either its power or its position. Governance, being something of a whole, has not to leave any ambiguity anywhere. What wrong is done when the judiciary fills up a vacuum? What wrong is done when any organ other than the judiciary is supported by the judiciary? Judicial activism operates in a situation of some vacuum when it is required. Judiciary does not begin making laws on its own, nor does it carry out the administration. Justice Verma rightly says judicial activism is that which ensures proper functioning of all organs, and the best kind of judicial activism is that which brings about results with the least judicial intervention. If everyone else is working, we do not have to step in. Judicial activism is the judiciary acting, judiciary in action, and not judiciary in intervention. Judicial activism is not one where judiciary takes up an activity, but it is one where it is asked to take action on someone else's stance, public interest, litigation, including S.P. Gupta, Union of India 1982 case. The Supreme Court granted accessibility to persons to invite judicial action against the abuse of power or misuse or inaction of the government, both the legislature and the executive. It may be said that the Supreme Court had come to the rescue of workers. People's Union for Democratic Rights, Union of India 1982, Bonded Labour, Bandhu Mukti Morcha, Union of India 1978, Payment Dwellers, Olga Telly's Bombay Municipal Corporation 1985 under trial detainees Husainra Khatun, State of Bihar 1979 inmates of protection homes Upendra Bakshi, State of Uttar Pradesh 1983 and the victims of Bhopal gas disaster Union Carbide Corporation Union of India 1991 in Ratlam Municipality Bridichan 1980, the Supreme Court sought to activate administrative machinery when it failed to perform its legal obligations. In Common Cause Union of India 1996, the Supreme Court cancelled the allotment of petrol pumps made on grounds of nepotism and malafide and passed severe strictures against the then Minister of Petroleum and Natural Gas. All these cases indicate that the judicial activism has its own importance. A word of caution with regard to judicial activism comes from Dr. A.S. Anand, former Chief Justice of India. He says, courts have to function within the established parameters and constitutional bounds. Decisions should have jurisprudential base with clearly discernible principles. Courts have to be careful to see that they do not overstep their limits, because to them is assigned the sacred duty of guarding the Constitution. Courts cannot create rights where none exist, nor can they go on making orders which are incapable of enforcement or violative of other laws, or settle legal principles with a view to seeing that judicial activism does not become judicial adventurism. The courts must act with caution and proper restraint. They must remember that judicial activism is not an unguided missile. The failure to bear this in mind would lead to chaos. Public adulation must not sway judges, and personal aggrandizement must be eschewed. It is imperative to preserve the sanctity and credibility of the judicial process. It needs to be remembered that the courts cannot they cannot run the government. The judiciary should act only as an alarm bell. It should ensure that the executive has become alive to perform its duties.